Hi guys, and welcome to another episode of Attorney Job Vlogger, Law for the Everyday Layman. Today we'll take a part 4 on the law of negotiable instruments, and we'll be talking about negotiation and endorsement. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So, as I may have mentioned in my previous videos, no, there are three methods of transferring an instrument, no? Not necessarily a negotiable instrument, but any instrument. There is issue, the very first transfer of the instrument. There is negotiation, which applies to negotiable instruments. And there is also assignment. Now, as for the difference between negotiation and assignment, as well as the definition of assignment itself, I have talked about that already in my previous video. Okay? So now let's just focus on negotiation. As I may have explained before, negotiation is simply the transfer of the instrument from one person to another in such a manner as to constitute the transferee the holder thereof. He is now the transferee is now a holder, okay? And the holder is simply the payee or endorsee who is in possession of the instrument or the bearer of the instrument with the right to collect the sum due on the instrument, okay? Now, we can have an instrument which is payable to order or payable to bearer. An instrument payable to order is negotiated by endorsement, okay, coupled with delivery. However, please take note, there can also be an incomplete negotiation of an order instrument. Okay? As I said earlier, the negotiable instrument can be, if it is an order instrument, can be negotiated by endorsement, signing the name, okay, and if in case of special endorsement, the designation of to whom it is endorsed, no? Let's say to A and then signing by the endorser. Okay, that is the endorsement. Or it can also be a blank endorsement by signature only, no? Okay, now coupled with delivery. Okay, endorsement with delivery for instruments payable to order. But what is this incomplete negotiation of an order instrument, no? So this happens when the current holder, let's say me, no, I transfer the instrument for value. I get value for this without endorsing it. I just gave it, no? Okay. In this case, this transfer is not a negotiation but is a mere equitable assignment. Okay? The transferee, in other words, simply gets the title of the transferor. Okay? And he also gets an additional right to ask for my endorsement. Okay? He can come to me and ask me to endorse it to him. Okay? So, in this case, the transferee, the person who receives this, he is not a holder, but he is a mere assignee, and he acquires the instrument subject to the defenses available to prior parties. Okay? Now, in this case of an incomplete negotiation, okay, yung without endorsement, okay, the negotiation can only take effect. Negotiation will only happen if that transferee to whom I transferred this is able to get my endorsement. And it is only from the time that he gets my endorsement that he becomes a holder. Okay? Now, this is important, okay? Because the time of endorsement or negotiation, no, which was determined again by the time that he obtains my endorsement, that is important because that will help us determine if he is a holder in due course or not. Okay? Why? Let's give an example, no? Let's say I transfer this for value to an assignee, okay? But since there is no endorsement from me yet, okay, he is a mere assignee. And before that, if he acquires any knowledge of a defect on the instrument, such as forgery, insolvency, whatever, no? If he has a knowledge of any defect on the instrument before he acquires my endorsement, then he is not a holder in due course. And he does not get the rights of a holder in due course. Why? Because the negotiation will only take effect after after he has obtained my endorsement. Okay? Okay, so that's it for a payable to order. But what about payable to bearer? It's very easy. I mentioned this earlier in my previous videos, no? Instruments payable to bearer are negotiated by mere delivery. Endorsement is not necessary. You can, but it's not necessary. An instrument payable to bearer will always be payable to bearer and can be negotiated by mere delivery. Now let's talk about the more important matter, no? Endorsement. And what is endorsement? As I said, it is the writing of the name of the endorser, okay, the person endorsing, on the instrument with the intent to either transfer the title or to strengthen the security of the holder by assuming a contingent liability. I sign my name to assume a contingent liability for its future payment, okay, or both, can be both. I want to transfer title and I want to assume contingent liability on the instrument. Okay? So, endorsement is not only a mode of transfer, but it is a contract. You have to remember what I talked about in my previous videos, that one of the characteristics of negotiability is the accumulation of secondary contracts. Okay? So, except for the qualified endorser, every endorser, no, to the instrument, except for the qualified one, is a new debtor for the terms on the face of the instrument. Okay? And he gets an additional obligation. And what obligation is this? That if the instrument is dishonored by the person primarily liable by either non-acceptance or non-payment, and if I am given notice, if that endorser is given notice, then he will be liable and he will pay for the amount on the instrument. Okay? Now, the qualified endorser, as I mentioned earlier, is not necessarily liable for the terms of the instrument. Okay? I'll be discussing that later on, no? But the qualified endorser will only be liable for the breach in his warranties. Okay? I'm saying that early on, but I'll discuss that more in a bit. Okay? So let's give a few rules on endorsement, no? First, the endorsement must be of the entire instrument. Okay? Entire instrument. Except if part of the instrument has already been paid, then the remainder, whatever is left, no, can be endorsed. Okay? It may be endorsed as to the residue. Okay? Now, if let's say it's not been paid, no, it's still full, no? If the endorsement transfers only part, let's say this one in this case is 1,000, no? If the endorsement transfers only part, no, I sign pay to A or order only 500. That's not a negotiation, that's a mere assignment, because again, the rule is endorsement must be of the entire instrument. Okay? Also, take note, no? An endorsement which transfers the negotiable instrument to two or more persons, no? Okay? Severally, meaning separately or individually. Such as here again, 1,000, then I say pay to A 800, pay to B 200, no? I divided the 1,000 into different portions for the two people. That is not allowed. Okay, that is not a negotiation. Okay, however, if the endorsement is joint, no, if I say pay to X and Y, that one is a valid negotiation. Okay? Now let's go to the second rule in connection with that, no? If the endorsement is joint, no, pay to X and Y, okay, or payable to the order of two or more payees or endorsees who are not partners, every one of them must endorse. So if I say pay to A and B, now when A and B have this note and they want to endorse it, both of them have to sign. Okay? Both of them have to endorse it further. Okay? Cannot be only one of them unless they are partners or unless the one endorsing has authority from the other person or other persons, if plural, no? Next rule, no? If a person is endorsing in a representative capacity, like an agent, no? He may endorse in such terms as to negate his personal liability. Okay? So he won't be held liable on the instrument because he's only acting as a representative, no? So he just has to add words describing himself as agent, like A, agent. He must disclose his principal for principal X, no? And his power as an agent must be duly authorized in writing. He must have an SPA. Okay? Now, fourth rule, no? if the negotiable instrument is drawn or endorsed to a person as cashier or other fiscal officer of a bank or corporation, the instrument is deemed prima facie, only prima facie payable, no, to the bank or corporation of which he is an officer. And it may be further negotiated by endorsement of the bank or corporation or even of the officer. Okay? But that is only a disputable presumption, and it may be proven by the cashier or fiscal officer that the instrument was negotiated to him or endorsed to them in their personal capacity, meaning that they are the ones really entitled to the instrument. Okay? Now, final rule, okay? In case the name of the payee or the endorsee is misspelled, okay? When he endorses it further, no, to someone else, he may add his proper name or signature, okay? If he just thinks fit, no, it's not a mandatory rule on his part. If he wants, he can correct the name. Okay, now let's go to the classification of endorsements. Now, first we have the special endorsement, okay? And a special endorsement is simple, no? It specifies the person to whom or to whose order the negotiable instrument is to be payable, okay? In other words, I just say 2A or 2X. That is already a special endorsement, okay? And in order for that instrument to be negotiated further, then that person who was specially named has to sign it as an endorser, okay? So he must endorse X, or A in the previous example, must endorse it in order to further negotiate the instrument, okay? And that is especially true for order instruments. But when it comes to bearer instruments or those payable to bearer, it does not matter. Why? Because an instrument payable to bearer is always payable to bearer, even if endorsed specially. So it can be negotiated by mere delivery, okay? So take note of that, no? Next kind of endorsement is a blank endorsement. And what is a blank endorsement? If the special one names someone in particular, like 2X, in blank, it's just the signature of the endorser. There is no 2X, 2Y, 2Z, no one. Okay? Just signature. And then I give it to someone. Okay? Now, that's easy for payable to bearer, because payable to bearer instruments are can be negotiated by mere delivery. I'll just give it to this person, then he gives it to someone else just by delivery, no? Even if you don't sign, doesn't matter, okay? But in case of an instrument payable to order, okay, you can convert that instrument payable to order into one that is payable to bearer. How? By making a blank endorsement, okay? So, let's say the first endorsement is special to A. Okay, so that's a special endorsement. If A wants to negotiate it to B, he can do it either by specially endorsing, saying to B, signed A, or he can just sign it without designating to whom it is being endorsed to. He can just sign his name, signed A, without saying to B. Okay? So that is a blank endorsement, okay? So, now that blank endorsement, okay? Remember the signature, okay? That blank endorsement is, the effect is to make that instrument payable to bearer. And can you convert that bearer instrument into a special endorsement, no? Can you convert rather that blank endorsement to a special endorsement? Of course, no? If A merely signed his name without designating B, then B can write over the signature to B, okay? He can now protect himself, okay? He can write any contract that is not inconsistent with the endorsement to him. What does that mean? No, that's simple. B is allowed, if it was negotiated to B by just the signature of A, B can write to B, then over the signature of A. Okay, but B cannot write, no, to B, comma, demand waived, okay, or protest waived, or any other character which A did not say. Okay, A can only be bound by what he actually promised, no, and the only thing A promised in that case was that he is transferring the instrument to B. Okay. So just remember, if it's a bearer instrument, it is negotiable by mere delivery, and even if it's specially endorsed, okay? Once a better instrument, always a better instrument. Next kind of endorsement is the absolute endorsement. Okay? In this case, the endorser simply binds himself to pay on no other condition than the failure of prior parties to pay and on due notice of such failure. Of course, there must be notice of dishonor for non-acceptance or non-payment. Okay? So, next kind of endorsement is the conditional endorsement. Okay? Take note, conditional endorsement. Okay? Because if the instrument itself is conditional, okay, then it's not negotiable. Because remember, one of the requisites for a negotiable instrument is that it must contain an unconditional order or promise to pay. Okay? A sum certain in money, okay, etc. No? But it must be unconditional. But the endorsements on the back, in the negotiation of the instrument, it may be subject to a condition. Okay, now the right of the endorsee or the person who receives the instrument is now made to depend on the happening of the condition. Okay, now let's talk about the liabilities of the parties. No, the party primarily liable, no, like the maker or the drawee in case he accepts, in which case he will be the acceptor. He can pay and disregard the condition. Okay? He doesn't have to wait for the condition to happen. Why? Because he has the right to terminate his obligation upon maturity of the instrument. Okay, para wala na siyang problema, no? He will disregard the condition. And now, what will only happen is that the endorsee, okay, or the holder rather, the person who receives the payment, will now have to hold those funds subject to the condition. And if the condition does not happen, the funds that he held in trust must now be remitted to the person who endorsed the instrument to him. Okay? So, let's say, maker to payee, then payee endorses to A, then to B. Okay? When A endorsed it to B, it was a conditional endorsement. And let's say the holder, si B, wants the maker to pay. Okay? The maker can actually pay right away after maturity, after maturity, in order for him to terminate all his obligations. But if the condition does not happen, then the payment received by B, which was held in trust, should now be given to A because the condition did not happen. Okay? If that is the case in the example. Okay? So, let's go to the next kind of endorsement. We have the restrictive endorsement. Okay? And the restrictive endorsement can come in three forms. No? First, one that prohibits the further negotiation of the instrument. And in this case, the instrument is no longer negotiable. Okay? It can no longer be negotiated further. Second case is a restrictive endorsement which constitutes the endorsee as the agent of the endorser. Okay, this is otherwise known as an endorsement for deposit. Okay, he just holds it for the endorser. And finally, an endorsement is restrictive if it vests title in the endorsee in trust or for the use of any other person or persons. Okay? Now, the mere absence of words implying the power to negotiate, okay, absence, mere absence of words implying power to negotiate doesn't make the endorsement restrictive. Okay, it has to be clear. The restrictive nature has to be clear. And how do we know? I'll give you some examples. If the endorsement is simply pay to A, then that is all right, no problem, no? But if it says pay to A only, then the only makes it a specified person, pay to A only. And now, the instrument is non-negotiable. Okay? So, the effect of a restrictive endorsement is to give the endorsee certain rights. Okay? First, he can receive payment on the instrument, he can bring any action that the endorser could bring, and he can transfer his rights as endorsee if the form of the endorsement allows him to. And in this regard, please take note of the rule of continuation of negotiable character. Okay? Once an instrument is initially negotiable, when it was made, it was negotiable, it will continue to be negotiable until it is restrictively endorsed by prohibition or if it is finally discharged. Okay? Okay, I'll talk about that more later, no? Now, let's go to the next kind of endorsement. We have the qualified endorsement, okay? And the qualified endorsement, as the name implies, means that the endorser makes a qualification, okay? The effect here is that the endorser is now a mere assigner of title of the instrument. He is only an assigner, okay? How do we make a qualified endorsement? No, you just add words which are similar to sans recourse, without recourse, endorser not a holder, or at endorser's risk. Okay, that or similar words, no? And all these things just mean without a resort to the person secondarily liable, meaning you cannot run after him, you cannot hold that specific person who wrote those words liable, okay? In case of default of the person primarily liable, okay? Now, this qualified endorsement, it's usually resorted to or used, no? In case the endorser, the person who makes the qualification, wants to transfer his title, but he does not want to assume responsibilities under the secondary contracts, okay? Remember, the characteristic of negotiability is accumulation of secondary contracts. Let's say the endorser does not want to be held liable on that, then he just makes a qualified endorsement, okay? Now, a qualified endorser has only limited liability. Remember, no? He's a mere assigner. So, his only liability is the liability for breach of warranty. If the instrument is dishonored, no? Either by non-acceptance or non-payment due to the following cases, no? Breach of warranty, he is liable in case of forgery. Why? Because the warranty as to genuineness of the instrument is breached, okay? Warranty, he is liable in case he does not have good title, no? Because he breaches the warranty of good title. He is liable in case of lack of capacity to endorse of prior parties who came before him, no? He is also liable finally in case the instrument is valueless or not valid and he knew, okay? He knew, if the qualified endorser knew of the fact that the instrument was valueless or not valid, okay? Okay, so I'll give an example na lang, no? If the maker, no, the person primarily liable, if the maker refuses to pay because his signature was forged, okay? I don't want to pay, that's not my signature, no? If the maker says that, then can the qualified endorser be held liable? Yes, because he warrants that the instrument is genuine. But if the maker cannot pay because he is insolvent and the qualified endorser did not know about the insolvency, then he is not liable to pay. Okay? Because again, he assumes no liability other than for the breach of warranties which I mentioned earlier. Okay? Okay. Now, please take note also, no, one of the effects of a qualified endorsement is that the qualified endorsement does not impair the negotiability of the instrument. Okay? It is still negotiable even if there is a qualified endorsement. Okay? The subsequent holder can negotiate it further. And finally, the qualified endorser is liable to all parties who derive their title through his endorsement. Okay? For the breach of warranties, of course. Okay? Now, next kind of endorsement would be a joint endorsement. And we discussed this already in passing. And just as a reminder, if an endorsement is payable to the order of 2 or more persons, then all of them must endorse. Okay? Except if they are partners or if the payee or endorsee has authority to endorse for the other. Okay, finally we have the irregular endorser. Okay, take note, this happens before delivery, no? If a person who is not otherwise party to the instrument places their signature thereon in blank, okay, before delivery, then he is considered to be an endorser. In fact, an irregular endorser. Okay? Now, take note of the rules, no? If it is payable to the order of a third person, then he is liable to the payee and all subsequent parties. If it is payable to the order of the maker or drawer, or if it is payable to bearer, then the irregular endorser is liable to all parties subsequent to the maker or drawer. And finally, in case the irregular endorser signs for accommodation of the payee, he is liable to all parties subsequent to the payee. Okay? Now, let's go to some more rules. Okay, actually, these are presumptions, no? First presumption as to the time of endorsement. Now, why is this important, no? The presumption as to the time of endorsement. It's important because for a holder to be considered a holder in due course, he must have taken the instrument before it was overdue. Okay, meaning it's not past its maturity date, it's not past its due date. Okay, so the general rule is negotiation is deemed prima facie. Okay, it's a disputable presumption. Negotiation is deemed prima facie to have been effected before the instrument was overdue. That's the presumption. Exception, if the endorsement, okay, bears a date after maturity of the instrument. And under section 11, if the endorsement bears a date, that is presumed to be the true date, not due date, true date. Okay? Now, next presumption. Presumption as to the place of endorsement. This is simple, no? Every endorsement is presumed to be made at the place where the instrument is dated. So, if there appears a date, then there's a place, Manila, then the endorsement is also presumed to be done at Manila. Okay? Except, of course, where the contrary appears. The endorser writes a specific place. That's also the rule, no? Okay? So, if there's a specific place written, then we follow that. If none, we presume it to be at the place where the instrument is dated. Okay? Now, let's go to a very important and a bit complicated matter, no? Let's talk about the striking out of endorsements. Okay? Now, the rule is, in case of many endorsees and endorsers, no? A, B, C, D, E, F, G, whoever, no? There are cases when endorsements may be stricken off. But let's talk about the rule first, no? The holder may at any time strike out any endorsement which is not necessary to his title. Take note, no? An endorsee will derive his title through the person from whom he derived it. In case of a bearer instrument, it does not matter because it's by mere delivery. But in the case of an order instrument or special endorsements, you can trace it from whom your title is derived from. Okay? So, in case that the title of certain endorsers are not necessary to your own title, you can strike them off. Meaning you can delete them, no? Or cross them out. Okay? So, the endorser whose endorsement is struck out or erased or deleted, no? And all endorsers who subsequent to that person, no? So, let's say C, D, E, F, G, no? G wants to strike out C to F, no? Not only C, but also E, F, G, E, F, no? Everyone subsequent to C are also relieved from liability on the instrument. Okay? Now, take note. If the instrument is negotiated by special endorsement, meaning to A, no, then signature. If the instrument is negotiated by special endorsement, the holder has no right to strike out such endorsement. Okay, he cannot strike out that endorsement, nor can he convert that special endorsement to a blank endorsement. Why? It will be stupid for him to do that. Why? Because remember, I just said earlier, you have to be able to trace your title in case of special endorsements, no? If you are A, B, C, D, E, you have to be able to say, I got it from E, I got it from D, C, B, etc., no? You have to follow that in case there is an intervening blank endorsement. So, you cannot cross those out. Okay? Because otherwise, the maker will not, the drawee or the person primarily liable will not know how you got that title in case of special endorsements, huh? But in case of blank endorsements or bearer instruments, that's not such a big problem because that's negotiable by mere delivery. Okay? So what are the cases when the holder may strike out an endorsement? Okay? First, the holder may strike out an endorsement if it is payable to bearer on its face. I mentioned this earlier repeatedly, no? Why? Because if this is a bearer instrument, I can simply negotiate this by mere delivery. I can strike out any and all instruments. Why? Because all I have to rely on is what is written on the face. It says payable to, let's say, X or bearer. Bearer lang yung titingnan ko. Only bearer. And I am the bearer. So you will now pay me. Any title here in the back does not matter to me. Okay? None of them are necessary to my title. Okay? But now here comes the more important rule. If this is an instrument originally payable to order. Okay? An instrument payable to order is negotiable, is negotiated by endorsement coupled with delivery. Okay? And you can only strike out the endorsements in two cases. First, when it is reacquired by a prior party. Okay? So, meaning someone, a prior party has received the instrument again through negotiation. Okay, so the rule is where an instrument is negotiated back to a prior party, such party may reissue and further negotiate the same. But he cannot enforce payment thereof against any intervening party to whom he was personally liable. Why? Because with respect to prior parties, he is remitted to his former position. So since he's already in his former position, he can strike out his own and any subsequent endorsements because they are not necessary to his title. Okay, so let's give an example, no? So let's say here, si Kung Fu Panda. Kung Fu Panda makes an instrument, a negotiable instrument payable to, let's say Goku. Okay, pays it to Goku or order. Okay, Goku now negotiates it to Gohan. Okay, and Gohan to Trunks, and Trunks now negotiates it to Vegeta. So far, there are how many people already? 1, 2, 3, 4, 5. Okay, Vegeta. Okay, Vegeta now renegotiates the bill to Gohan. Okay, he wants to pay his debt to Gohan, and he uses that instrument, and Gohan accepts it. Okay, so now Gohan receives the instrument, or rather reacquires the instrument. Okay, Gohan can further renegotiate the bill, and now let's say he renegotiates the bill to Frieza. Okay, Frieza is now the current holder. Frieza asks Gohan to pay, and let's say Gohan pays. Okay, now what are the rights and liabilities of Gohan? Okay, Gohan cannot claim payment from either Trunks or Vegeta. Okay, he cannot claim payment from them. Why? Because if Gohan asks for payment from Vegeta or Trunks, because remember, he got his title again. He reacquired the title from Vegeta, no? If he asks Vegeta and Trunks to pay, no? Then, they will simply ask him to pay back. Why? Because they in turn derive their title from Gohan. Okay? Remember, the situation went Kung Fu Panda, Goku, Gohan, Trunks, then Vegeta. Okay? So, in the order of preference, no? Gohan will be liable to Trunks and to Vegeta. So, if he holds them liable, okay, they can hold him liable again. See how circuitous that is? No, it goes around in circles, no? This is to prevent multiplicity of suits. So the law just says that if Gohan reacquires it from a subsequent endorsee, then he now cannot hold them liable anymore. Okay? Who can Gohan run after? He can run after the maker, who is the Kung Fu Panda, or he can hold the original payee, Goku, liable. Okay? So, what about Frieza? Can Frieza enforce payment from the parties? He can enforce payment from any one of them. Okay? Take note, anyone. The problem is really with Gohan. Okay? So, remember when I mentioned earlier that Trunks and Vegeta, Gohan cannot claim payment from Trunks and Vegeta. And since originally Trunks and Vegeta derived their title through Gohan, and since Gohan was able to reacquire the bill, no, then Trunks and Vegeta are no longer necessary. Gohan can now strike out the endorsements of Trunks and Vegeta. Okay? Because he is remitted to his former position where he obtained his title from Goku. Okay? So, that's how the rule works. Okay? Final note, if Gohan does strike out Trunks and Vegeta, as I said earlier, he can do that. Remember, he will strike out the endorsements to Trunks and Vegeta. Then, Frieza can no longer hold Trunks and Vegeta One because it's as if they have been removed from the instrument already. Okay? And finally, take note, a prior party cannot renegotiate the instrument first if it is payable to the order of a third person and it is paid by the drawer. Second, if it is made or accepted for accommodation and it is paid by the accommodated party. And finally, if the instrument is discharged. Now, these rules are under, the final one is under 119 and the first two are under 121A and B. Okay? So, just take note of that. Okay, now let's move on. No, the second rule, when the second instance, when the endorsements may be stricken off in case of an instrument payable to order. The second is when that order instrument becomes a bearer instrument. Okay, remember how does an order instrument become a bearer instrument? If the only or the last endorsement is in blank, meaning there is nothing written at 2A or 2X, nothing. It's only a signature. Okay? So when the blank endorsement is now followed by a special endorsement and the holder strikes out all the endorsements subsequent or after the blank endorsement, then the instrument now becomes payable to bearer. Okay? It can be now negotiated by mere delivery. Why? Because the last endorsement is in blank. Okay? In other words, special endorsements are not necessary to the holder's title. Okay? Because he could have acquired the same through mere delivery. Okay? However, please take note, this is very important. The endorser may not strike out the payee's endorsement. Okay? Why? Because the instrument is payable to order in this case. And the endorsement of the payee is necessary for the instrument to have been negotiated in the first place. Okay? So, payee must specially endorse, and then it can be endorsed in blank by that subsequent endorsee, and everything after that can now be crossed out. Okay? So, it will be as if the holder would derive his title from the blank endorsement. Okay? So, that's it, no, for negotiation and transfer. Please just remember also the rule of continuation of negotiable character. That's very important. An instrument, if it is originally negotiable, continues to be negotiable until either restrictively endorsed by prohibition of further negotiation or when finally discharged. Okay? So I hope you may have picked up a thing or two, and please stay tuned for my next video. Okay? See you soon, guys. Bye!